Good afternoon. Good afternoon. Just want to be sure you're out there and you're not an illusion. I'm having some voice issues, so please bear with me. But my name is Calvin Sharp, and I'm the founding director of CISCDR, the acronym for the Center for the Interdisciplinary Study of Conflict and Dispute Resolution. Founded in 2005. CISCDR sponsors 3 distinguished lecturers annually. The CISCDR Distinguished Scholar in Residence is typically a legal academic who does theoretical scholarship about conflict and dispute resolution. Professors Mikometer, Mnookin, and Karapkin have delivered this lecture since the founding of CISCDR. And I see some familiar faces of those who have attended some of those lectures. The CISCDR Distinguished Interdisciplinary Lecturer is a scholar from a non-legal field with important things to say about conflict and dispute resolution from a different perspective. Dr. Maya Angelou and Dr. Stephen Post have delivered this lecture as Dr. Gordon Feldman, a distinguished sociologist from Tufts, will in the fall of 2009. Today's lecture, the CISCDR Distinguished Visitor Lecture, features a world-class practitioner in the field of conflict and dispute resolution. Previous lecturers have included such luminaries as Dennis Ross, a former U.S. envoy to the Palestinian-Israeli conflict in the Bush 41 and Clinton administrations. He's, as you probably know, just been assigned to serve at that role in the Obama administration in Iran. And Ken Feinberg, a special master of the 9/11 Victims Compensation Fund. Today's lecturer builds upon this developing tradition of preeminent practitioners in the field. He's an arbitrator and mediator of over 5,000 labor management disputes since 1957. He's probably the most influential national and international teacher, trainer, scholar, consultant, and designer and practitioner of labor management, arbitration, and arbitration systems in this era, and that is not hyperbole. I won't try to recite his entire resume, but I do want to give you a flavor for his accomplishments. He's a graduate of Tufts, the Yale Law School, and the Harvard Kennedy School of Government. Currently, he's vice president and judge of the Asian Development Bank and Administrative Tribunal. He is chair of the Steering Committee on Labor Standards for the Permanent Court of Arbitration in The Hague. A consultant to the governments of the U.S., Australia, Cambodia, Greece, Israel, Italy, the Philippines, and South Africa, as well as to international organizations such as the International Labor Organization, the ILO, the International Monetary Fund, the Inter-American Development Bank, and the UN Development Program. He's been a member of 4 presidential emergency boards, chair of 2 of them. He's been a Fulbright scholar, designing the conciliation service for the government of Ethiopia. He's been a lecturer in dispute resolution, labor, and work-life program at the Harvard Law School since 1985. He was the president of the National Academy of Arbitrators in 1994-95. He's co-chair of the task force which developed the due process protocol, which I'm sure many of you have heard of, for the mediation and arbitration of employment disputes. And I could really go on for quite some time about his professional service and various appointments to pivotal posts during his exemplary career of more than 50 years. He's received numerous awards for his contributions in the field of dispute resolution. And if all of that were not enough, he's written over 120 articles and 12 books. So please join me in welcoming my friend and colleague, Arnold M. Zack, who will talk about designing dispute resolution machinery in the employment context.
Good afternoon. As they say, if my father heard that, he'd have been proud of me. If my mother heard it, she'd have believed it. How many of you have experience in the labor management field or interest in the labor management field? And so it's a good number. All right. You have my paper. You have an earlier draft of my paper, so there's a couple typos in it I discovered. And I could merely read the paper, but I think what I'd like to do is focus more on the role of the designing of dispute settlement systems and how it's happened in the labor field, and sort of use labor as an example of how you can do system design in dispute resolution. United States, our tradition and our background has been that we live in a society of laws, and that we have laws that protect us on matters of our working conditions, but those laws are not very prevalent. We don't have very many laws to protect us in workplace. We have minimum wages, and we have laws governing wages and hours. We have laws governing protection against discrimination for age, sex, gender, for involvement in people with disabilities, protection against all kinds of forms of discrimination. We don't have the detailed laws that a lot of countries have to protect people at the workplace. And when you look at Europe, when you have in the code countries, very explicit laws. Now we have evolved from the statutes, we've evolved them to a society where certain conditions are established and either granted unilaterally by the employer or have been negotiated through collective bargaining that do provide greater workplace rights than the mere statutes. For instance, we would all assume that the provision of the laws would entitle us to paid holidays. Well, the laws provide for holidays, but not paid holidays. We all assume there would be laws governing paid vacations. There are no laws requiring paid vacations. We would assume there are laws requiring provision of health care. I think we all know now that health care may be a function of employment, but it's not a prerequisite for whether you're employed or not, except if you're above age 65. So we have laws, and then we have practices, and we have an institution in the United States which is called collective bargaining, by which employees have had the right to form, join, and assist in the creation of labor organizations of their own choosing. The National Labor Relations Act of 1935 gave that right, and employees, if they have a majority of employees in a bargaining unit, have the right to unionize, and the employer has the obligation to negotiate in good faith over terms of conditions, wages, hours, and employment. Now that's a negotiated dispute resolution procedure. It's one that has been created by the parties, authorized by the law, and it's something that the parties design themselves. Every collective bargaining agreement has its own design. They follow certain patterns. What they all have, by virtue of the fact they all dealing with unions and all dealing with management with repeated leadership by both unions and management in their development, they all have their own private judicial system called the grievance and arbitration system. And that's for the enforcement of their collective agreement. Those agreements are enforceable by law because of statutes and Supreme Court decisions. Our established judicial institutions have allowed the parties to develop their own dispute resolution system. And they call for enforcement of that. And Section 301 provides for enforcement of the contracts. The unions have the right to organize and to engage in contracts. And the court has said in the Steelworkers Trilogy, this is a contract between union and management. We recognize that as a good system. The parties select their own judges, they set up their own dispute resolution system, and it is better for us to respect what they have done than for us to come in and look over their shoulders and second guess whether their decisions were correct or not. The United States and Canada have that system. They're the only countries in the world that really have it. It's amazing. One would think that that's a universal, but it is not so. The United States and Canada have a very unique system where they have, by virtue of statutory authorization, been allowed to design their own dispute resolutions at the workplace. And one would think that it is a prevalent system. Well, the reality is that it is not. Even in the United States, at the greatest number, there were 54% of the workforce organized in the private sector in 1954. Now, in the private sector, it's almost 8%. We have a workforce of 120 million people. That means 110 million people don't have the protections of collective bargaining. It's staggering. And everybody says, these terribly powerful unions are destroying the country. Well, 8% in the private sector. And, listening to the debates on the contract at General Motors and the awful things that the employers have to subject themselves to because of collective bargaining. Those are all things that employers granted. They were employers' rights to do what they wanted to do until they had collective bargaining. There was nothing that says the employer has to give these things up. The employer granted benefits that workers now have because that was the price of getting collective agreement. They could have gone on strike, they could have locked out, but they didn't because they designed their own system for resolving these disputes, and that included the tug of war, the give and take in negotiations, which led to those collective agreements. And then they negotiated the judicial system, say, well, if we have a dispute as to what this agreement means, we will go to a grievance procedure, and then we will select an arbitrator. Now, Calvin and I arbitrate labor management disputes. We are selected by the disputants. They've heard of us. They've heard of others. Sometimes they use us. Sometimes they say, oh, we don't want to use that person. We want to use somebody else. But they have their own system for resolving those disputes. That's what they designed. And it runs to a very small percentage of the workforce. I'm afraid the unions are given far more credit than they are entitled to for having this enormous power to destroy the American economy on benefits that were the employers, that the employer gave up in order to reach agreement. Those were not taken from the employer, they were given by the employer. So that's what we have in the United States. We have a system of laws covering everybody, 120 million people in the workforce. We have collective bargaining for that small group of about 8% in the private sector, 40% in the public sector, an average of about 12% of the workforce that has carved out and negotiated its own structure. That structure has given the impression that arbitration is a good thing, a credible thing, because arbitrators are pretty well accepted as neutrals. I should add, Paul Gerhardt, I should mention you as another competitor of mine. We're out in the free market. This party select whom they want as an arbitrator. And we don't have, because they have the freedom, we are there for hire. What keeps us neutral, I think, is the fact that the parties have a number of people to choose from, and they select those neutrals, whom they want for a particular case, based on the scuttlebutt they've heard from other people, based on our written awards. Each side pays us half, which I think is probably the single thing that keeps us clean. We don't have a tilt that, if I decide for so-and-so, maybe I'll get another case, because that works both ways. So, balances out. And we have, I don't know how many arbitrators there are, what, maybe 5,000 people who claim they're, of course, you never get a case as an arbitrator until you say, I'm an arbitrator. So your first case, you have to say, I'm an arbitrator even before you become one. So there are about 5,000 self-proclaimed arbitrators, and probably about 10% do 90% of the cases, because the parties keep coming back to us for whatever reason. Maybe it's Darwin's theory of survival. That reputation given to the dispute designed by unions and management has carried over into the employment field where there is no unions. Employers have capitalized on the reputation that comes with arbitration and mediation and have said, we're going to set up a system for our non-union employees. This happened in got its genesis. The genesis, I suppose, goes back to 1925, when the Federal Arbitration Act was passed. Now, that was an act that was created to resolve disputes between commercial partners. I'm in Boston, and I order fabric from a mill in Cleveland, if there were any left, and I have a pattern, a sample, and it comes. He says, "This is what I ordered. I ordered green. This is blue. I'm not going to pay for it. It's not what I ordered." In those contexts, the Federal Arbitration Act anticipated that there would be an arbitration structure where the employers, where the two parties could hire a mutual expert who knows that field to resolve the dispute between them. Final and binding, no appeal, no need for the courts to review. The courts aren't experts in the weave of fabric or the colors of fabric. And they said, we don't want anything to do with it, said the courts. That's what legislation is for, to make a private arbitration. In a sense, that's sort of what has happened in the labor management field. The courts said, we don't know that. We don't have that expertise. We leave it to the parties to set up their own system. So, but what happened as a consequence of 1925 statute, which was confined to commercial until about 1990, there was a case that arose in 1990 of a stockbroker by the name of Gilmer who was fired. He was age 52. He was replaced by somebody who was much younger. And he said, this is a violation of the Age Discrimination in Employment Act. And he went to court. And the court said, yeah, it may be, but we haven't got jurisdiction on this because you signed an agreement to arbitrate when you went into your employment as a stockbroker, that any dispute you had with the employer would be resolved by arbitration. And Gilmer says, well, this is a statute. He says, your agreement said any dispute. And although you had a statutory right, you surrendered that statutory right in favor of going to arbitration. Well, I never negotiated the arbitration agreement. I don't have a union. It's me. When you signed, all those papers you signed when you took your job, one of the papers said, I agree to arbitration on this scheme that is established by the employer unilaterally by the securities industry. It's not just the single employer, not just the agency brokerage for which you work. And it said that I will subscribe to arbitration as the exclusive remedy for resolving any statutory disputes I have. And the Supreme Court, in the Gilmer decision, said, that's it. Did you know what you were doing? Yeah, I signed it. It was a piece of paper. Did they force you to sign it? No. I could have gone, the court said, well, you could have gone to work someplace else. Well, in fact, he probably couldn't. He was a stockbroker, and everybody, all brokerage houses, you had to sign that U4 agreement. And so, but that became the law. And then in the court in 1990, in a number of cases since that, have said, look, as long as it's knowing, and as long as you had the form, you signed it. And as long as you did it voluntarily, you agreed to be bound by that. So here's, I go to work at age 23, feeling fine, and I sign this agreement that says I waive my right to go to the Americans with Disability Act claiming a violation. Can't go to court. The statute calls for trial by jury. I waived it. And the Supreme Court, at least this court, has been supporting those agreements And employer promulgated systems now are the way for a number of, several million people, we don't know how many, who have no recourse to courts because they have given up. Now, that's system design, but that was designed solely by the employer. So when we talk about dispute resolution system design, I hope we're talking about something where both parties are participants in that design, both sides, both disputants. In the employment arbitration, it's designed by the employer. In fact, most of the agreements, quote, which the employees sign as a condition of getting a job or a condition of retaining a job. Some of the companies put these things in after people are already employed and said it now applies to you. Well, no consideration. All right, we'll give you days off, days pay. That's your consideration. You want to stay, work here? You want to continue to work here as a consideration. Now, that system is a unilaterally denied system. I don't think it's fair. I think it's a contract of adhesion, but the Supreme Court has repeatedly found otherwise. But there is some legislation. There will be legislation under this administration. There is legislation pending, which will say you cannot impose that kind of agreement prior to a dispute. After a dispute, if that was a system and I had a choice, I'm X years old and I have a disability and I want to build a ramp to my machine and the employer says no. If after that happens I have a choice of going to arbitration, fine. Then I have a free choice of going to arbitration. But when it is made a condition of employment, I think it's a contract of adhesion. It forces people into it. So it's an alternative dispute resolution, but it's one designed by the employer. Now, I raised the labor management and the employment issues as two types of dispute resolution design that we have in this country. Together, if there are a lot of people covered by the employment, it's still 100 million people with no protection other than the statutes, which is a far cry from Europe, where statutes are far more prevalent, where you have multiple unions, not a single union, as here, and where the employer negotiates with the unions are usually based on political parties. They have works councils, all the unions get together in the enterprise. Here we have one union or no union. So the employers fight that union. If they get no union, then they don't have to deal with collective bargaining. But in the European system, there are multiple unions. There are works councils. All the unions get together in the enterprise, and they negotiate the terms and conditions of employment, all by statute. And they have labor courts to deal with questions that would otherwise go to arbitration in the United States. But the labor courts and the court system are judicial dispute resolution systems, not designed by the parties, but they are prevalent. And what I want to you haven't had time to read my paper, and nor do I. And but I'm going to sort of track it along. But what I want to talk about this evening is we have a system of laws, judicial dispute resolution, and we have a system of alternative dispute resolution, which is not necessarily judicial, not statutory, and not judicial. In the United States, that's arbitration. Some good, some I don't feel comfortable with. What do they have in other countries? And what do they have in the third world? And that's what we want to focus on. We have good system, not widely used, but a good system. The Europeans have very good systems, I think in many ways better than ours. What about the rest of the world? What about the rest of the world? All these European countries had colonies. All the French colonies in French Indochina. They have laws just like their former colonial masters had. In Latin America, you have laws as Spain had that followed a lot of the Spanish laws. In Africa, a lot of the countries have followed the British laws. So throughout the developing world, you have a lot of statutory dispute, a lot of statutory statutes that protect workers, usually labor inspectors, usually some form of labor courts, but they don't have the jobs, they don't have the enterprises, they don't have the money. They are the developing countries, and they lack any of the industrial success that underpins our systems in the UK, in the European countries, and in the United States. Yet these are the countries to which jobs are going. Now, we have lost in the United States all kinds of manufacturing jobs. We all know that. I grew up in Lynn, which used to be the shoe capital of the world. My father was a factory worker in a shoe factory in Lynn. And after the war, Second World War, those factories moved to St. Louis. And that's because that's where they got the hides from, and that's where the market was moving southwest. And so we lost the jobs. We lost the textile mills in New England. They moved to the south. Cheaper labor, closer to sources, closer to the cotton, closer to the market. And industry now moves overseas. We can't stop it. We shouldn't want to stop it because we can get things, that's the international trade operates that way. We lose, we gain. We lose, we gain. And, if it weren't for our ability to send things overseas, we wouldn't have the economy we have now, funded entirely by the Chinese. But we wouldn't have that we have now. So we have international trade, and there is the right of the employer to go to maximize its profits. The question that I have, and the question underlies the paper, and what I want to talk about, is we have systems here that resolve disputes. We have laws, not as many as we should have in the United States, but we have laws in Europe that govern working conditions. What's going to protect the workers in the developing world as these jobs leave? I thought I had an answer until last September and October, and I'll go through that, but I think things have gotten much worse since that, which I think are will come out of it. Whether these other countries will and how long it'll take them to come out of it, I don't know. I think there is very serious problems, particularly as this evolves in China. We have in developing countries national laws that are not enforced. We have national laws that don't have the personnel to do the enforcement, that don't have the knowledge of the enforcement, that don't have the desire to do the enforcement, and desperately need the money that they get by graft. And that's where the jobs go, because the employers find that they can move and make more money if they go overseas. The jobs that are going overseas are unskilled jobs. They're assembly jobs. There's only one article of clothing that is made 100% in the United States that we consume. Everything else goes overseas to be assembled, to be sewn. And imagine how, if it's cost effective, you make something in Cleveland. I mean, you get the fabric or something, you make the parts in the United States. You send it on a ship or on a plane to someplace in China. They spend a couple of weeks sewing it together, and they send it back to you, and it's cheaper than if it were made here. Astounding. But that's the reality. And the fact is that those things are moving abroad, that we've lost shoes that went from Boston to St. Louis, to Guangdong, which is a town about an hour outside of what used to be Canton, which has 1,400 shoe factories that produce 1.2 billion pair of shoes a year. China in total produces 6.2 billion pairs of shoes every year, more than enough shoes for every man, woman, and child in the world every year. They produce 50 to 60% of our computers, refrigerators, washing machines, stoves, 70% of our furniture, 100% of the shipping containers. And all of those things go overseas, and they are not regulated. They're not covered by U.S. laws. They're not covered by European laws. They're covered by Chinese law. But before we get, I'll get to that in a minute, but they leave the United States and they go to Southeast Asia or to China. What laws control? What protection is there for the workers in these countries against the exploitation that would not only permit the maximization of reasonable profits, but maximization of profits at the exploitation of those workers? and that's a concern that I have. I think we all have. Our laws don't apply there. Their laws are not enforced there. There are no international laws governing wages, hours, and conditions of work. We have fair trade agreements, about 30 of them, that we've negotiated with other countries to give them access to our market and to provide protection for our workers, our jobs overseas. All of those free trade agreements, NAFTA, CAFTA, and all the others, provide that there will be protection of intellectual property. But there's nothing there that says we're going to protect the rights of the workers. Now, what are the protections that are fair for the workers in the absence of national law, in the absence of international law? The answer to that, I think, is in the International Labor Organization. The ILO, founded in 1919 as an agency of the League of Nations, is now a specialized agency of the United Nations. China actually was an initial member, but it was a different government than they have now. It is composed of 3 organizations. It's a workers group, an employers group, and a government group. It's tripartite. And they have negotiated since almost 100 years now what unions, labor management and neutrals, labor management and government members thought to be fair standards. The first ILO convention said, what we really want for a fair standard in the world is a 48-hour week, 1919. Now it's a 40-hour week, so they've changed. But there are 8 fundamental conventions that I think the world has come to accept as the basis of fairness, and most important as jobs move to the developing countries. 2 of them involve freedom. 2 of them involve no child labor. 2 involve no forced labor. 1 involves no discrimination on gender, and another involves other forms of discrimination. 1 involves the employees having the right of freedom of association, and the last one is the right of collective bargaining. Now, management, labor, and employers have agreed that those are fundamental conventions, and they were initiated about 1900, 1920, but they have been updated. And those are, everybody says, that's fairness. If we can get all the companies in the world, I would be happy to surrender the right to have air conditioning or the right to have benefits or the right to work X number of hours, as long as we could set an international ban against child labor, forced labor, and grant people the right of collective bargaining and right of freedom of association. Those latter 2, they are pro-union, yes, but trade unions have, to my estimation, proved to be the building blocks of democracies in a lot of countries. And I think they are terribly important for that which we proclaim is the ideal of self-regulation and the ability to develop their own private dispute resolution structures around the world. So those fundamental core conventions are indeed the standard. A lot of countries have adopted them. A lot of countries don't follow them. Of those 8, we've ratified 2. We still have we have not ratified the Convention Against Forced Labor. We still have not ratified the Convention Against Slavery because we produce under slave conditions in prisons. Things are made for the commercial market in a lot of state prisons, and we're not clean enough to have eliminated slavery in the United States in the year 2009. So there are no national laws that work in these developing countries. There are no international laws that apply. The trade agreements deal with protection of employers' intellectual property rights, but none of them have. Well, there's one. There's our fair trade agreement with Jordan has the social clause. We've tried to get the World Bank, we tried to get the Asian Bank, tried to get the Inter-American Development Bank, the European Bank for all the regional banks, European Bank for Reconstruction and Development, World Trade Organization to adopt a social clause, which says we will not give money for the development of a dam on the Yangtze River or for the development of highways in Brazil unless the contracts are let with the understanding of conformity to the social clause, that there be conformity to these ILO conventions. Haven't been able to get it. Nobody's been able to sell it. The debate between Hillary and Obama in the campaign about NAFTA only dealt with the question of, can we get NAFTA redone so we can insert the social clause? It's not to eliminate trade, but it's to say that there ought to be fairness in the working conditions in all the countries with which we trade. And we haven't gotten there yet. All we have, the only protection I can see in dealing with the conditions facing workers in countries to which our plants have run, are the ILO conventions. Now, we did have, and who's going to enforce them? The countries aren't going to buy them. What pressure is there? The pressure, I think, has evolved with the, initially starting on the campuses in the United States in the 80s, when students began to rebel against the logo sweatshirts of their colleges and universities that were made in the Marianas and made in sweatshops. Sweatshirts against sweatshops, or whatever it was called in the 80s. And there was a lot of student activity and protest, and out of that came a real change in the way garments were manufactured, because all the garment manufacturers were very susceptible to boycott, very concerned about other companies doing good, and they would lose that business, because there's a lot of fungibility when you're buying a garment. You're going to buy A or B. They look the same. And so there evolved this, the companies began to adopt codes of conduct and said, we are clean. We will conform to standards. We will not engage, and environmental and the blue-green kinds of issues. And said, we're clean, this is how we produce. Come buy from us. And that has worked very successfully. And if most of the garments you find and that you wear, most of which are made overseas, are made by companies that have adopted codes of conduct that they're going to be respectful of workers' rights and the protections of the ILO conventions. A lot of those companies are all overseas. In 1994, President Clinton created the response to this multi-fiber agreement with Bangladesh, Sri Lanka, Cambodia, Indonesia, and Vietnam. And said, we will give you larger quotas in the United States for your products, your garments, your sportswear, your shoes, sneakers, if you will conform to fair standards. And so these countries agreed to conform to that. And one of those, where I spend some time, is in Cambodia. In Cambodia, the government said, we will do that. We want the larger share of the quotas, larger quotas, and we will provide fair standards for people working in Cambodia. And what has evolved there is a gem. The government has created a monitoring system. Some of these brands say, we're going to monitor clothing, we're going to monitor our factories, because, when you go to buy things from Gap or something that has a Disney logo, it's not made in downtown Cleveland, it's not made in downtown Kuala Lumpur, it's not made in Disneyland. It's made in a number of places around the world. Disney buys its logo clothing wear from 52 countries, 17,000 factories. The Gap is about 3,500 factories in the same number of countries. And so I was talking with the guys from Disney in Hong Kong a while ago, and we were talking about they've opened a new theme park in Hong Kong, and they've just now opened one in Koi Lin in the ice palaces in Harbin. And they said, we're going to conform to these standards. And I said, well, how many factories do you have in China? He said, we don't know. because we have numbers that we contract with, but then they contract with, and then they contract with, and, the shoelaces are made, far away. How do you monitor this? The companies can't, imagine the cost of trying to monitor this with 17,000 factories, when you have a few hundred people whom you employ as monitors, and with those monitors come back to you and say, oh, you're violating 87 and 98, you got to allow these people to organize. So they pay for the monitors, they hire the monitors, or they monitor themselves, and it's not always clean monitoring. But what happened in Cambodia, the ILO said, we're going to monitor. So the ILO monitors, and the expectation, this multi-fiber agreement started in 1994, the expectation would be the end in 2004. At the end of 2004, they had 250 factories, employing 250,000 workers, about 1,000 workers a factory. And after that, they didn't leave. They didn't go to China. They stayed. And today there are 350 factories, and there are about 370,000 people working in the garment industry in Cambodia under fair conditions. And they went and designed their own dispute resolution system. They designed the system to be bound by the ILO conventions. They set up a system for the monitoring, and then they set up a system with an arbitration structure to monitor and to resolve disputes between companies and workers and unions over whether there has been adherence to these conventions. There they have, their system is, they have 30 arbitrators. There's a panel of 10 labor arbitrators, 10 management arbitrators, and 10 neutral arbitrators. And the disputants select one from their side. The employer will take someone from the management arbitration list, the workers from the workers' arbitration list, and they'll agree on a neutral. And they have a very viable, thriving system for resolving disputes. To date, they've resolved about probably about 300 disputes by now. And they resolve about 85% of their disputes. It's a system that they themselves designed. And they have very few cases that they designed it, but it had to be consistent with Cambodian laws. So there's a right of appeal. And so they have a choice of having binding arbitration or non-binding arbitration. Usually they go for non-binding. Non-binding keeps it clean because it's a very corrupt society, extremely corrupt. Government's corrupt, and that's why this system is a gem, because it's private and it's clean. And what makes it thrive is that they designed the option of making it binding or non-binding. They were afraid to go binding because then there may be corruption among the judges. If it's non-binding, you can have a decision, and if you don't like it, you walk away from it and go to court. A variation for what we would expect in our system, but applicable to their structure. And that works very well. And so there has evolved in this one country of Cambodia a really good system for bringing conformity to labor standards and providing a fair workplace. And that system has done pretty well. It is hit by the decline in business since November. Orders are down in the factories about 30%. But what they have negotiated last December, instead of having layoffs, they've negotiated to share the work. So they're down to a 30-hour work week. Everybody continues to be at work. The benefits of their own design of a unique system for their situation. It works well. So why not the rest of the world? Well, the fact is, when you're talking about garment industry, when you're talking about clothing, when you're talking about shoes, when you're talking about toys, you're talking about 5% total of world trade. That rest of the trade where there's no constituency, nobody needs codes of conduct because there's nobody looking over their shoulder, so they can get away with what they want. And the exploitation is rampant. And a lot of that stuff has gone to China. And I just want to wrap up by talking. I haven't even started my speech yet. Oh, screw it. You got it. You can read it. If you find there are about 8 typos in that version, so you can send me the corrections if you find more. So what happens in China? So these companies all go to China. Now, China is a worker's paradise, right? 1949, someone says no. 1949, the Chinese government came in, the communist government came in, and they said, this is a workers' paradise, we're going to own everything. So therefore, workers don't need protection. So therefore, you don't need a trade union. The employer will watch out for you. Compared to what they had, it was very good. And that remained extant in 19, I have to get the year, 1976 and 79. I think the constitutions provided for the right to form, right to engage in collective bargaining, and right to strike. But then in 1978, Deng Xiaoping said, we want to open up China, and we want to start trading with the rest of the world. And we will allow foreign enterprises to come in, FOEs, foreign-owned enterprises to come in and employ the Chinese. It's work for us, and we can produce cheaper, and therefore we'll get the market. You know, very sagacious. And that's what's happened. And they say, we have a trade union. And it's called the All-Chinese Trade Union Federation. And there is a law that said, as of November 30th, of this last November 30th, every foreign-owned enterprise, FOE, had to have a representative of the All-Chinese Trade Union Federation, their trade union movement. Now, their trade union is not a member of the workers' body in the ILO. In fact, it's not even recognized by the AFL-CIO. Is it a trade union? It is funded by a 2% payment, 2% payroll tax of every enterprise goes to that enterprise's union, ACFTU chapter. The head of that ACFTU chapter is appointed by the president of the company. The ACFTU does not represent the workers. It will facilitate dispute resolution between the individual employee, there are no collective disputes allowed, needed rather, and the employer. And they go through they have discussion, they have mediation, they have arbitration, and then they go to court. And the ACFTU will handle these, but it is not a party and it is not a workers' representative. So although prior to 1978 there would have been a right to have a union, there were no free enterprise, there was no private sector, so there was no really need for a union. But then when you had the foreign-owned enterprises coming in, which are now 1/3 of the enterprises in China, the ACFTU said, continue the same, we're going to put you in the ACFTU. What the Chinese ignored, which is beginning to cause very serious problems, is that when you have a boss under the communist system in a state-owned enterprise, there is respect for and loyalty to the workers and to the country, or pressures, if not loyalty. When you have a private-owned enterprise, the loyalty is to the dollar, and which can be exported as rapidly as possible. They are there to make profits. And so and despite that, the Chinese government did nothing to protect the workers in those state-owned, in those foreign-owned enterprises. And they continue to say the ACFTU has to represent them, but the workers are not interested. The fact is, Walmart, which has 150 operations in China, welcomed the ACFTU. And if Walmart's going to welcome something that's called a union, it can't be a real union. So the profile at the present time has been that you have a lot of companies, or up until the fall, you had a lot of companies operating in China. You had some, and the Chinese legal structure provided for arbitration of individual disputes. There's no collectivity, there's no real trade union, so there's no collective disputes. There are no collective bargaining agreements between the parties. And you had only for those enterprises, foreign-owned enterprises that had codes of conduct, you might have had adherence to a procedure for resolving disputes within those subcontracting enterprises. If the company had a code of conduct that went beyond garment industry, if the code of conduct provided for an investigation and monitoring in China, which is difficult, and if after the monitoring and the investigation there was a willingness to develop a dispute resolution system to see if the company was indeed living up to its commitment and its code of conduct. So the reality is there's not much supervision, there is not much monitoring, there's not much fairness in Chinese workplace. Now comes the crash of October, September and October. Since that time, there have been enormous cuts in the operation of a lot of these state-owned and foreign-owned, particularly foreign-owned enterprises, which I say are 1/3 of the companies. Chinese employment is based on internal migratory labor. China has 1.2 billion people, a workforce of 632 million people. It has migratory laborers of about 170 million, 160, 190 million people. All the factories are in the Pearl River Delta, the Yangtze River Delta, and Beijing, the deep water ports. Stuff comes in, offloaded, assembled, put back on the ships, goes out and sold. There's no economic development in Chongqing, Chengdu, 10, 20, 30 hours by train into the interior. There's nothing there. There's a lot of drought, there's a lot of unemployment, but the people come from there, and the able-bodied workers get permission to go down to the coast, and they work there. They live in dormitories, and they provide the income for the people back in the rural areas, where the average farm is 1/10 of an acre to support the mother and father. The kids are down in the coastline. China has had an annual GMP of about 11% a year, 11, 12% per year increase. They can't sustain that now because the jobs are leaving, the orders are being canceled, the factories are absconding, and they're now down to 5% GMP anticipated for this year. That 7% difference funded everything that is done internally for the state-owned systems. The number of people unemployed in the Pearl River, Yangtze River, and deltas is enormous. I keep getting figures, and they're staggering. They are now 10,000, 20,000, 30,000 factories shutting down in a province. We have no idea how many people are unemployed. The Chinese are releasing a lot of that data. We do know that of the 170 million people, about 70 million, they all go home for the Chinese New Year. They get their money and they go. So they live in dormitories, so they work and they don't get paid. When it's time to go home, they'll give them a paycheck. Well, they're not getting a paycheck now. And a lot of these companies, the owners are from Taiwan, they just leave. And these people are unemployed. They go home. They can't survive at home. The rural economy doesn't support them anymore. The money they've been sent home to build houses and to buy bicycles or to buy a TV set is gone, and no resources. They report last week said that 20 million of these 170 million have come back looking for jobs, even though they got fired, are looking for work now in places where they can't be sustained. We have no one there. Anyway, make a long story short, and we can talk about this later afterwards if you want. What has happened the disputes, there's 500 disputes filed, 500,000, disputes filed in arbitration last year, and these are all failure to pay. They're all statutory issues. They didn't pay my wages that I was contracted for. It's not that I got fired for unjust dismissal, none of that stuff. They're just paying. They're all statutory violations. They don't know what the number's going to be this year. There are tens of millions of people unemployed. There are tens of thousands of factories shutting down in these areas as a consequence of what happened in the fall. And what has been an economic problem of unemployment now verges on being a political problem for the Chinese government. And that's pretty staggering. I just want to close by saying, I started, when I did this paper, and its precursors, my thought was maybe we can develop a system where these companies will have a viable, we'll get more of them going in China. We'll get more receptivity. The Chinese government does permit for arbitration. It does permit for private dispute resolution system. I said, my thought was if we could get If we could develop an international roster of mediators to go out and resolve these disputes, if we could get the companies that are purchasing from China to have factories there, to set up systems of fairness, then maybe we could improve the workplace conditions in China. But now what has happened with the economy, I mean, we're hurting, but they are hurting. And they are hurting in a political, we have stability in this country. We should relish it. And what's going to happen there? Nobody knows. Let me just quote you from paper, New York Times, day before yesterday. About 40% of this town, of 2,000 residents, work outside the province, and their remittances have been a lifeline for the children and the elderly people who remain behind. Much of that money has been spent on motorcycles, high school education, new homes. Now the people are back, and they have not come back with money. This week, more than 3,000 public security directors from government agencies around the country are gathering in Beijing to learn how to neutralize rallies and strikes before they blossom into so-called mass incidents. At a meeting of the Chinese cabinet, the Prime Minister told they should be prepared for rough times for the rest of 2009. The country's employment situation is extremely grim. That's what's happening in China, and that's where all of our stuff is being made. And we are so fortunate with the loss of jobs, despite this awful economic situation which we're now living, there is at least, stability in this country. And we have a lot to be thankful for compared to what's going on in these other countries. I know that President Clinton the other day, former President Clinton the other day, told Obama to end his speech by being upbeat. You have to listen to Obama because I can't quite get there with what's happening in China and workplace dispute resolution. Thank you very much. Now you have to read the paper because it's really quite different from what I guess.
We have time for maybe one or two questions for Arnold. Please use the mic.
Yeah.
Thank you. I have one question. You said that a third of the foreign-controlled enterprises are.
Yeah.
What percentage of the gross domestic product of China is controlled by foreign? Is generated by foreign-controlled enterprises?
I would suppose majority. There's 2/3 of the enterprise, and that's where China's in more trade. The state-owned enterprises are, making local stuff for local production, but not for international trade. I don't know what proportion of it, but I think it's probably everything.
I said one, and is the bulk of that ownership in the hands of U.S. foreign-controlled enterprises?
No. Formosa, Taiwan, Korea, Singapore, Hong Kong. I do work with Hong Kong Law School. And there are a lot of companies that are based in Hong Kong, but just shells in Hong Kong, but their factories are in mainland. And a lot of European. We have the garment stuff, well, what we buy. All the labels, the machinery we buy now is largely Chinese manufactured. It's worldwide. But I don't know what the ownership of the companies is. The market's worldwide. Paul.
Yeah, please. I want to get you on the web.
Arnie, I've been puzzled for a long time about what it is that motivates the development of procedures. And what occurred to me probably 15 or 18 years ago on some of my first visits to Russia, where I was asked, how do you develop these procedures? And wouldn't it be great if we put arbitration wouldn't that help the workers a lot if we got some kind of an arbitration procedure? But the reality is that in this country, if you look at just the labor management environment, and I think this probably applies across the board to all kinds of procedures, but I'd like your reactions to this thought, that coming from the field of economics, I tend to think that...
I got one of those, sorry.
I tend to think that the motive for creating a procedure is that it will somehow be less costly than the alternative of fighting it out. And the fighting it out only takes place if both sides have a lot of power to inflict damage on the other side. So I don't see a lot of hope for China or even Russia, for that matter, to develop these kinds of procedures, at least until there's some kind of a powerful, independent, as you suggested, independent labor movement that can really inflict costs. Maybe not gain very much, but they can inflict a lot of cost, and that would be the motive. What do you think about that?
I don't think you have to have power on both sides. I mean, you know, these systems are developed out of self-interest. I haven't done any work in Russia, but I've worked in the Ukraine when it was part of Russia, so that, I guess that counts. And I got involved with a bunch of people who wanted to set up an arbitration system in the coal mines in Donetsk, which was then part of the Soviet Union, but then became part of the Ukraine. And I had the people from the mines who were Russian, and although in the Ukraine, and I had the mine workers who were also Russian and Armenian, but living in the Ukraine. And they wanted to have a dispute settlement system to resolve their disputes because they hated the Soviet master who owned the mine. And so, you know, I tried to develop some sort of structure where best we could get was mediation. The best we could get is a willingness to talk because the power imbalance was so great. So when you talk about ADR, if you talk about arbitration, you're talking about a sharing, a willing, self-confidence or fear or overwhelming power that you're willing to submit to another party to make that decision. Mediation is different. I think if you recognize that there's conflict, mediation becomes a more promising avenue because then you may be able to get somebody to help you persuade the other side to reach an agreement. For arbitration, I think it is power, but I don't think it has to be equal power because on the one side, one party may have the power and, you know, we want an arbitrator because we're gonna win. And the other party says, we want an arbitrator to protect us against that power. So it need not necessarily be balanced, but it is true. It's the alternative is greater chaos than what they already have. But I think the universal is to persuade people that their self-interest makes it better for them to move towards a resolution over which they have control through mediation than a resolution in which they've given up control to the government or to an arbitrator, private, judicial or non-judicial. It doesn't matter. But I have no prospects of thinking of arbitration, any of the stuff I'm doing overseas, except, you know, Cambodia, they already have it there. And we've done some, Calvin and I have done some stuff in South Africa where they developed a private arbitration system because they had relatively equal power in the automobile industry prior to the end of apartheid. But mediation is something I'm more likely to espouse.
Okay, well, we're gonna have a reception shortly, where you can continue the conversation.
Can I read my paper then?
We'll read your paper after you leave. But I do want to give Arnold Zack a memento
isn't that nice?
Of his time here and our appreciation. This is a
And it's
crystal clock with the correct time. It says Case Western Reserve, University School of Law, February 25th, 2009. Arnold Zack, Sister Distinguished Visitor Lecture. So thank you, Arnold, and we also have a tote bag for carrying it.
Terrific. Thank you so much.